Good evening, everyone. We're going to give it a few seconds to get started so that folks can join us. All right. Hi, everyone, and welcome to the DPU and EFSB Intervenor Support Grant Program. I'm Kessel John, and I'm with ERG, a contractor supporting these meetings. Before we get started, I have some interpretation logistics to go over. This meeting is available with interpretation into Spanish, Portuguese, Haitian Creole, Mandarin Chinese, Vietnamese, and ASL, or American Sign Language. In a few moments, I'm going to turn on interpretation, which will show up in your Zoom control panel as a globe. Once that pops up, you can click on it to select your desired language. English speakers should select English to hear any translated comments. I'm now going to turn it over to Dan to go over this in each language.
Thank you. The language announcement will now begin. To participate in English, please click interpretation icon and select English. For Portuguese, please.
Para participar no canal em português, clique no ícone Interpretation e selecione Português.
For Spanish, please.
Si alguien desea interpretación en español, haga clic en Interpretation y seleccione Spanish.
For Haitian Creole, please.
C'est quelqu'un là qui a besoin d'interprétation, s'il vous plaît, cliquez sur l'icône globe là et puis choisir interprétation et puis sélectionnez créole haïtien. Merci un peu.
For Mandarin Chinese, please.
如果以中文普通话参加会议，请单击口语图标并选择 Chinese。谢谢。
For Vietnamese, please.
Để vào kênh bằng tiếng Việt, hãy nhấp vào biểu tượng Interpretation và chọn Vietnamese.
Language announcement completed. Thank you.
Thanks. All right, I'm now going to go ahead and turn on interpretation. All right, everyone should have just seen a globe icon pop up in their Zoom control panel. If you don't see it, please click on More, indicated by 3 dots, and interpretation should be on the menu that pops up there. Closed caption is available for this meeting in English by clicking on the CC icon, also in your Zoom control panel. If you have audio issues during this meeting, you can call in by clicking on the arrow next to the audio icon, selecting Switch to Phone Audio, and following the instructions provided. If you have any technical difficulties during the presentation, you can message me in the chat box or email meetings@erg.com, and I'll troubleshoot the issue with you. I'd also like to remind everyone to speak slowly and clearly when giving comments for our Zoom interpreters. That's all I have for Zoom housekeeping, so now I'm going to turn it over to Julianne Desmet.
Thank you. At this time, we can go on the record. Good evening, everyone. This is a public hearing being conducted in person and virtually via the Zoom webinar platform. This is regarding DPU 25-75, investigation of the Department of Public Utilities on its own motion instituting a rulemaking pursuant to General Laws, Chapter 164, Section 148, General Laws, Chapter 30A, Section 2, and 220 CMR 2 to establish requirements for the Intervenor Support Program, 220 CMR 34. My name is Julianne Desmet. I am a hearing officer for the Department of Public Utilities and the presiding officer for this proceeding. With me on the bench is Chair Jeremy McDermott, Commissioner Stacy Rubin, and Commissioner Elizabeth Anderson. Janine Vargas, Chief Deputy General Counsel for the department, and Veena Damaraj, Director of Environmental Justice and Public Participation. This hearing is hybrid, with participants appearing here at the department and present via the Zoom link and audio-only telephone number provided in the department's order dated September 12, 2025. The Zoom link and audio-only telephone number permit members of the public and any interested party to view or listen to today's hearing. Please note that this hearing is being transcribed by a court reporter and is being recorded by the department for later viewing on the department's YouTube channel. The official record for each proceeding will be the transcript being created by the court reporter. Interpretation for this hearing is provided in Spanish, Portuguese, Chinese, Haitian Creole, Vietnamese, as well as American Sign Language. Please ensure that you speak slowly and clearly for both the interpreters and the court reporter. A recording of the English and interpreted languages, as already stated, will be posted on the YouTube channel after this hearing. We are also joined by staff from ERG who are serving as this evening's hearing monitor. The hearing monitor enables and facilitates the online and audio portions of this hearing and provides access to hearing participants and members of the public that requested the opportunity to comment in accordance with the notice issued by the department in this proceeding. If you are having any technical difficulty with the Zoom, please use the chat function to contact ERG. Please pay attention to the video during the course of the public comment hearing, and please stop speaking if I raise my hand. I will do so if we have a technical issue or if I need to interrupt a speaker to ask them to slow down or speak up to ensure that we are capturing everything for the record. Additionally, when you are speaking, the interpreters or the court reporter may interrupt to provide additional direction to ensure your comments are translated and recorded correctly. The purpose of today's public hearing is to give any interested persons an opportunity to be heard and to make their views known on the proposed Intervenor Support Grant Program regulations in order to assist the department with the rulemaking. In the department's September 12th order, the department announced a series of hybrid public comment hearings across the Commonwealth. This is the third of those hearings and is to focus on the department's Intervenor Support Grant regulations. The fourth and final hearing is this Wednesday, November 5th, and it will also be hybrid with the in-person component in Lynn, Massachusetts. That hearing will provide an overview of the Energy Facilities and Siting Board proposed regulations, docket EFSB 25-10. That presentation will not be made at this evening's hearing. Please see the Siting Board's website for more information on those proposed regulations. We are accepting comments on all the proposed siting and intervenor support grant program regulations at all hearings. In addition, the Department and Siting Board provided notice they will accept written comments on the regulations. Final written comments for both sets of regulations are due Friday, November 7th, 2025. Instructions on how to file those comments are in the notice on the department's and the Siting Board's websites. To date, the department received written comments on the Intervenor Support Grant rulemaking from the Conservation Law Foundation and joint comments from Eversource Energy and National Grid. After we complete these public comment hearings and review the comments, the department and the Siting Board will adopt final regulations. The 2024 Climate Act requires that we complete our rulemakings by March 1st, 2026. We note that the Department of Energy Resources is proposing regulations to implement the consolidated local permitting provisions of the Climate Act. In addition, the Executive Office of Energy and Environmental Affairs and the Office of Environmental Justice and Office of Environmental Justice and Equity at the EEA are issuing guidance for certain provisions of the Climate Act. Please go to their respective websites if you would like more information on those proceedings. Our hearing this evening will proceed as follows. The commissioners will provide opening remarks for approximately 10 minutes. Then Ms. Damaraj will present some slides about the program with a few comment prompts for you to consider. I will then check in and see if there are any procedural questions about the remainder of the hearing. Then we will open the floor to public comments. First, we will take comments from federal, state, local officials, followed by those who registered in advance, those who registered at the table this evening, and then those who did not register but would like to comment both online and in person. We will alternate between in-person participants and virtual participants. We will answer questions and clarify if we were able to at this time. During the comment portion of the hearing, if you wish to comment tonight, if you are present here in the room, please raise your hand. If you are online through the Zoom platform, please use the raise your hand function there. And if you are on the telephone calling in, please press *9 on your phone. Also, kindly remember that the department will accept written comments until November 7th if you do not wish to comment tonight. And we will take a break at 7:30 as to give a break to the court reporter and the interpreters this evening, and then we will reconvene, and we are scheduled to conclude at 9 p.m., but we could possibly end earlier if there are no other comments that we haven't attended to this evening. The department is overseen by a 3-member commission appointed by the Secretary of the Executive Office of Energy and Environmental Affairs, also known as EEA, with approval by the governor. All 3 members of the commission are here tonight. Chair Jeremy McDermott began his tenure on the commission in September 2025. Commissioner Stacy Rubin has served on the commission since April 2023. Commissioner Elizabeth Anderson is the newest member of the commission who joined in October 2025. The 3 commissioners are the decision makers who will issue a written decision to promulgate the final regulations on the Intervenor Support Grant Program. At this time, the commissioners wish to address tonight's participants, starting with Commissioner Rubin.
Thank you very much, Hearing Officer Desmet. Hello, and thank you so much for attending tonight's hearing. We're happy to host you at the department's hearing room in Boston. Again, my name is Stacy Rubin, and I am a DPU commissioner and a member of the Siting Board. We reached an important milestone tonight as we gather to share an overview of the Intervenor Grant Support Program proposal and to hear your feedback. Implementing the Intervenor Support Grant Program is one of the many steps that the department is taking to enhance participation and lower barriers to ensure meaningful engagement in both Department of Public Utilities and Energy Facility Siting Board proceedings. This program will provide community groups, smaller municipalities, and others who may be impacted by a proceeding with the resources to make their voices heard and shape decision-making. Many people in this room, in person and also virtually, have been working on these issues for years and are eager to see improvements to the process. Let me take a moment to explain how we got to today's milestone. Governor Maura Healey signed Executive Order 620 in September of 2023, which established the Commission on Energy Infrastructure Siting and Permitting. That Siting and Permitting Commission was tasked with reducing permitting timelines, ensuring communities impacted by energy infrastructure have input on the siting and permitting of such infrastructure, and ensuring that the benefits of the clean energy transition are equitable. The Siting and Permitting Commission had representatives from a diverse set of people, with representatives from labor, environmental justice, economic development, housing and real estate, environmental protection and land use, agriculture, local government, electric utilities, and the clean energy industry. That commission submitted recommendations to Governor Healey in March 2024, which informed legislation that was enacted in November of 2024. The new law, which we refer to as the 2024 Climate Act, reduces the time for permitting through a consolidated permit process, adds requirements for engaging with impacted communities, and should contribute to an equitable clean energy transition. We anticipate that there will be an increase in the number of clean energy projects that will seek siting board approval in the coming years. The 2024 Climate Act directs the siting board to issue consolidated permits, including state and local permits for clean energy infrastructure facilities. Facilities that are small clean energy infrastructure facilities will typically seek a consolidated local permit. The Department of Energy Resources held information sessions and a public hearing a few weeks ago to obtain input relating to small clean energy infrastructure facilities. I would now like to turn it over to Commissioner Elizabeth Anderson, our newest commissioner, to continue with our opening remarks.
Thank you, Commissioner Rubin. Hello, everyone. Good evening. I think just at the outset, I'd like to say this is a really important piece of that 2024 Climate Act, especially for consumers, and looking forward to participating in this process. And thank you all for being here and participating in this important process. As Commissioner Rubin noted, the 2024 Climate Act directed several processes to happen by March 2026. This has required the siting board and the department to initiate several different proceedings simultaneously. There is the siting board proceeding, docketed as EFSB 25-10. Tonight, we are focused on a separate but related proceeding at the department, focused on the Intervenor Grant Support Program, docketed as DPU 25-75. The program regulations have been informed by feedback we've received from community groups, the Attorney General's office, and others that will support greater participation and hopefully will provide some new perspectives to the Commission and the siting board to consider. In addition to this feedback, the department staff, as well as staff from the Executive Office of Energy and Environmental Affairs, the Office of Environmental Justice and Equity, and the Department of Energy Resources have held 4 stakeholder sessions last spring about siting and permitting to inform the draft regulations that we will discuss tonight. Staff representatives of the agencies met with stakeholders in small groups, but tonight is another opportunity for you all to share your ideas and give us feedback on these proposed regulations. We've also received initial written comments on the proposed regulations that were due 2 weeks ago. Those comments are posted to the respective dockets in the file room. Thank you for providing the initial comments, and staff are going to review those and catalog the comments received to consider further edits before to the proposed regulations. Final written comments are welcome by this Friday, November 7th. Information on how to submit written comments will also be available at the end of this presentation. And to give closing remarks, I would like to welcome our new chair, Jeremy McDermott.
Closing remarks to the opening remarks. Thank you, Commissioner, and good evening, everyone. Thank you very much for making time to come out to participate this evening. Again, I am Jeremy McDermott, the chair of the department and a member of the siting board. And I also want to recognize the work of our team. Getting these regulations to this comment period has been no small task for both the siting board and the siting division, as well as the department staff. And the team working on siting and permitting improvements has been working every day for more than a year to get us to this moment, and we're excited about where it's taking us. So it goes without saying, but we are deeply grateful for the staff for all the work that they put in to get these regs to where they are. As my colleagues have said, getting public input is essential to ensuring that these regulations achieve the collective goals of the siting board and the department in these proceedings. Traditionally, there's been a very high bar to entry in board and department matters. Stakeholders with financial and resources and technical expertise have traditionally been able to intervene and participate fully in these proceedings, hiring attorneys and consultants to represent their interests. By contrast, community groups, unincorporated local groups, and smaller municipalities with fewer resources and procedural knowledge have had fewer opportunities to engage meaningfully in these proceedings. The Intervenor Support Grant Program will address this unmet need, and the program will allow grantees to cover fees for attorneys, expert witnesses, consultants, community experts, and others to enable them to meaningfully participate in these proceedings. The funding will enable diverse voices and viewpoints to be considered by the department and the siting board through the decision-making process. And our goal in both the division, the department, and the siting board is, as always, to reach decisions that maximize the public interest by responding to stakeholder needs, improving transparency, and maximizing the efficiency. That way, we can arrive at decisions quickly, equitably, and fairly. So we look forward to your comments tonight and any written comments that you file by the end of this week. Our work is better when we have your input. And so, again, we thank you for making time out of your busy lives to come here this evening. And I will now turn it back over to Hearing Officer Desmet. Thank you.
Thank you, Chair and Commissioners. Next, we'll have Veena Damaraj provide an overview of the program.
Good evening, everyone. My name is Veena Dharmaraj. I'm the Director of Environmental Justice and Public Participation at the DPU. I'm really excited to share an overview of the Intervenor Support Grant Program. I want to thank all those who advocated for the program over the years, and staff who have been working really hard on all of the proposed regulations that we're going to be discussing today. We look forward to your feedback. The 2024 Climate Act establishes the Intervenor Support Grant Program and requires that the regulations to implement the program be promulgated by March 1st, 2026. The proposed regulations that we're going to be discussing today are informed by the statute, as well as the helpful feedback that we've received on the straw proposals and during informal discussions with stakeholders. The Act establishes the DPU Division of Public Participation, or DPP, and authorizes it with administrating all aspects of the program. As the Chair mentioned, traditionally, those who have been able to intervene in a DPU or EFSB docket have had the financial resources as well as the technical expertise to be able to do so. Community groups or smaller municipalities who lack the resources have not been able to meaningfully engage. The Intervenor Support Grant Program will provide financial assistance to eligible entities who are unable to participate in a DPU or EFSB proceeding. Grantees will be able to cover fees for attorneys, expert witnesses, as well as community experts. The program will make it easier for diverse voices to represent their interests and be considered during the decision-making process. Next, please. The Intervenor Support Grant Program will be funded through appropriations and assessments authorized by the 2024 Climate Act. It includes a portion of the 0.1% assessment on the revenue of electric companies and up to a 3.5 million assessment on the revenue of gas and electric companies that fall under DPU's purview. A portion of fees paid to the EFSB by applicants to construct clean energy infrastructure facilities will also be credited to the Intervenor Support Fund. The Act also authorizes DPU to credit appropriations specifically earmarked for the fund. Any unexpended funds will be credited against assessments made the following year. Next, please. Parties eligible for funding through the program are also informed by the 2024 Climate Act. It includes organizations that advocate on behalf of residential customers, low or moderate income residents, and residents of historically marginalized or overburdened and underserved communities. Government bodies such as towns, cities, boards and commissions associated with local governments, and school districts are eligible to receive funding. This includes regional planning agencies, federal and state recognized or acknowledged tribes. A group of individuals specifically and substantially affected by a proceeding can request funding to intervene. funds can be disbursed to grantees only after they receive intervener status in either a DPU or EFSB proceeding. Receiving intervener status is a prerequisite to receive funding. Individuals are not eligible to receive funding through this program. Next, please. To receive grant funding, the applicant needs to demonstrate that they lack financial resources to intervene and participate in a proceeding. To determine financial hardship, applicants will be required to provide information on the number of staff, total budget for their current fiscal year, the number of months of operating reserve that they have available with them, and Form 990 in case of a nonprofit with federal tax exempt status. Applicants will need to state whether they have previously intervened or intervened in a proceeding since the creation of the program. This is just one of the many criteria that will be taken into consideration. Previous intervention in no way automatically qualifies or disqualifies an applicant receiving a grant. The first two criteria that you see on the slide are required by statute, and municipalities with a population of less than 7,500 people are exempt from the first two criteria. To determine eligibility for grant funding, applicants will need to describe how they plan to substantially contribute to a proceeding. They will need to state if they have an achievable, clearly stated plan, and if they have a perspective that is distinct from that of other parties and adds value to the proceeding. The applicant will also need to identify the proposed budget item and the amount and how reasonable the funds are that they're requesting. Next, please. I'll briefly go through the process that the applicant needs to go to apply for funding. Grant applications should be submitted by the deadline to intervene. This is usually specified in the notice for the proceeding. DPP, that is the Division of Public Participation, will review the application for completeness within 10 business days and notify the applicant in case additional information is needed. Applicants will be notified of grant approval status as well as the amount of funding that is available within 30 days of the grant application deadline. Applicants may receive a conditional grant approval, but funds will only be disbursed after the applicant has been granted intervener status in either the DPU or EFSB proceeding. The 2024 Climate Act specifies that grant awards for a single proceeding should not exceed $150,000 per applicant and $500,000 for a single proceeding. Funding can be increased on demonstration of good cause or if there is a novel or complex or a new issue that comes up. Potential circumstances that could qualify for additional funding include multi-year proceedings, proceedings that address multiple issues or have multiple tracks, requirement for additional expert witnesses, or when new issues not described in an initial petition are identified. DPP will consider the potential for grantees to share costs when positions align. Next, please. The grant application form will require the applicant to submit a statement outlining how they plan to participate and make a substantial contribution, and a description of how the funds will be used. An itemized estimate of the costs for participating in a proceeding, such as fees for attorneys, expert witnesses, and community experts. They will also need to provide background information of attorneys, consultants, experts engaging in the proceeding that they've hired or are planning to hire, a statement describing the applicant's position and the nature of interest in the case, and any questions or concerns that they raised during pre-filing engagement meetings in case it is an EFSB proceeding. The applicant will need to provide information on the amount of funds that they are seeking. The application form will require information about the entity that is seeking the grant, a description of their nature of work, and a narrative to demonstrate that participation will pose a financial hardship for them. An unincorporated group applying for the grant will need to submit a self-attestation with the name and address of all individuals in the group, the number of volunteers or supporters if applicable, and a narrative explaining the group's collective mission and activities, as well as the level of financial hardship that they face. Next, please. There are two ways in which a grantee can request funding. They can submit a payment request upfront or request a reimbursement after costs have been incurred. For payment requests submitted before costs are incurred, an applicant will need to demonstrate financial hardship and include information in their request form, like their name, address, contact details, the docket number of the proceeding, the grant amount that has been awarded to them, as well as funds that they've received to date. The proposed regulations specify that grantees can receive up to 10% of the grant award before costs are incurred. But that's one of the questions that we have for you, and we welcome your feedback on that. Advance payment requests should also include itemized details of planned expenses and invoices. Grant payments can also be requested as reimbursements as costs are incurred all through the proceeding. Along with basic information that I described earlier, grantees will also need to self-attest and submit details of the funds that have been spent, activities that were conducted, as well as receipts. In both cases, grant payments will be made within 30 days of receipt of request if all information has been provided. The statute also sets a compliance requirement for the grantee, and the grantee is required to submit a report within 30 days of completion of the proceeding. The report needs to include details of how funds were used, how the grantee substantially contributed to the proceeding, and demonstrate that their participation did not delay the proceeding in any way. If the grantee appeals a board or a department decision, they will have an additional 30 days from the deadline of the appeal to submit their report. Next, please. The Act defines eligible use of funding. Funds can be used to retain qualified legal counsel, experts including community experts, and consultants to assist with participating in a proceeding. Up to 10% of the funding can be used for administrative costs. No more than 5% of the administrative costs can be allocated to a third party that has been hired to help with drafting of the grant application. Funds cannot be used for the purchase of equipment, to advertise or publicize the applicant's view on the proceeding, for political lobbying, and to appeal a final decision in a proceeding. And that's something that's from statute. Next, please. The Act also requires DPP to create multilingual educational materials that are accessible and easy to understand, program-specific forms and templates, as well as create an outreach program to inform and educate people about the program. DPP will be creating a program webpage with online resources and a guidance document to provide applicants with all of the information that they need. DPP will, in its annual report, provide information on the number of grant awards received or number of grant awards provided in a year, the funds awarded, the impact, as well as the contribution of those awarded the funding. By June 1st, 2029, DPP will review the program and have a public comment hearing to determine whether the program as well as the regulations should be amended in any way. Next, please. These are some questions that we're hoping to get your feedback on today. Please feel free to comment on anything on the regulation, but we wanted to get your feedback specifically on these questions. I'll just briefly tell you about these questions. So we wanted to understand if there are any Massachusetts-based organizations that can serve as a fiscal sponsor for grant applicants, particularly a group of individuals that is an unincorporated association. We'd also welcome any suggestions that you have on information, where we can find information, or if there are those who can work or those we can work together with to put an indicative fee scale for attorneys as well as expert witnesses that are working on cases relevant to either the DPU or EFSB. If there are any resources that are available to connect interested grant applicants with legal counsel, and should the reimbursement of administrative costs associated with drafting the grant application be limited to 5% as proposed in the regulation. With that, I'll be turning it over to Hearing Officer Desmond.
Thank you, Ms. Damaraj. At this time, I'd like to just take a brief moment to inquire if anyone has any questions about the remaining procedure or format of tonight's hearing. If so, please raise your hand here in the audience, on the Zoom platform, or press *9 on your telephone. Procedural questions. Seeing none, at this point, we can open the floor to public comments and questions. The purpose of this public comment hearing, again, is to hear comments on the proposed regulatory changes to implement the 2024 Climate Act and the department's regulations for the Intervenor Support Grant Program. Again, please raise your hand if you are in the audience. Use the function on the Zoom platform or press *9 on your telephone if you called in to notify the moderator if you would like to speak. Once we get through everyone that has signed up, we will alternate between any remaining participants that wish to comment tonight, switching between in-person and virtual participants as necessary. We will begin with federal, state, and local officials appointed as well as elected officials who wish to be heard, and then we will proceed with the members of the public who have signed up to speak in the order in which they have signed up, and then go to anyone that wishes to speak and has not had a chance to let us know in advance. If you are participating remotely and I call on you to speak, we will move you into the Zoom panel. This way you can be seen and heard by the Zoom audience as well as those here in the hearing room this evening. Please accept the invitation to be elevated to a panelist when you see the invitation. And for all speakers, please give your name and address and spell your last name for the court reporter. And most importantly, again, please speak clearly at a moderate pace. Do we have any federal officials present on Zoom that wish to comment or in the room here this evening? And I will note, I see one raised hand, Ms. Jindal, and we do have you on the list, so we are aware that you wish to make a comment. But I don't see anyone else that has raised their hand for federal officials. Are there any state officials present in the room this evening or on Zoom that wish to comment? No one in the room. Last call for anyone on Zoom, or we'll get to you at the end. All right, and local officials, I do have Jeffrey Weston that let us know he would like to comment. So he is a local official, and we'll start with him and then move on to any others that may be present. It just raised his hand, so he might.
All right, Jeff, I promoted you and you should be able to unmute yourself and turn on your camera.
And I'm unmute. Oh, I see. Wait a second. Great. Thank you for your patience. My name is Jeff Weston. I'm an elected member of the Shutesbury Planning Board. I believe that your section DI of your site suitability assessments on drinking water supply is actually dangerously incomplete. We are one of the 8 towns that borders the Quabbin Reservoir, one of the largest, mostly unfiltered water supplies in the United States. The Quabbin is the drinking water for approximately 3 million people, including you, Boston. Being part of the Quabbin watershed means that we have both surface and groundwater flowing from our town into the Quabbin. My great concern is the very high potential for both ground and surface water contamination flowing into our groundwater or the Quabbin or Atkins reservoirs caused by an unexpected lithium-ion fire. An extensive study published by the American Chemical Society shows that extinguishing water from lithium-ion batteries produces high concentrations of nickel, cobalt, lithium, manganese, and fluoride, which show a very high toxicity. Lithium fires also release PFAS chemicals, both into the air and groundwater. A lithium battery in a single Tesla car battery needed 6,000 gallons to put it out. Lithium batteries and solar arrays are literally 1,000 times larger. Energy storage systems with lithium batteries should not be sited above aquifers or near public or private water supplies where they could endanger the drinking water of Massachusetts residents. It is just not possible to protect water supplies with lithium when lithium-ion fires occur. We need your assistance to help us protect the Quabbin and Atkins reservoirs. The Atkins reservoir actually supplies UMass. Although a lawsuit against our solar bylaws has been withdrawn, it may be refiled in the future depending upon what you write in your final draft. The lawsuit that was filed against Shutesbury by Coles, the largest private landowner in the state, and Pure Sky, an international energy company, would have affected approximately 360 acres of our forested land,
Jeff,
according to
could you
documents
slow
filed
down
with our
slightly?
Conservation Committee. The Massachusetts Audubon and the Thompson Lab of Harvard
Excuse me,
Forest
Mr.
used their
Weston.
scientific study published on October 23 of 2023 to
Mr.
show how
Weston,
protecting our
they're just
natural and working
asking you
lands
to,
from development is critically important strategy in our response to the climate crisis.
Mr. Weston, they were just
One of the
asking
key
you to
findings of
slow
this
down.
report is that clear-cutting forests is actually counterproductive to our goal of reducing the concentration of carbon dioxide in the atmosphere. I can tell you with all certainty that the safety and purity of the water from the Atkins and Quabbin reservoirs, which are really the lifeblood of where you are in South Boston, that our town helps to protect, being one of the 8 towns that borders the Quabbin, is not at all guaranteed. Thank you for your time.
Thank you. Did the court reporter catch all of that and interpreters?
I'm done.
Mr. Weston, and we would invite you to submit some written comments. I tried to interrupt to get you to slow down in our court reporter and for recording. So if you want to type that up and submit it as a written comment, we got what we could. That would be much appreciated. Thank you.
I don't know if you can hear me any longer.
Yes, we can. Can you hear me? Seems he cannot hear me. Kessel, if you
can hear
wouldn't
you.
mind trying to chat.
Yes, I will put that information into the chat box.
Thank you. Okay, do we have any other local officials either present in the room or online that would wish to comment this evening? Okay, hearing none, we will next take comments from members of the general public, beginning with those who have pre-registered in the order in which they were registered. Again, when called, please give your name, spell your last name, and then give your address. So first, we had registered Carolyn Healy for a virtual comment if she is online. Don't see Miss Healy. Next, we have Mr. Brolin in the room.
Thank you, commissioners. Is this on? I think it is. Yes, great. I'm Ed Brolin. I am the Vice President of Distributed Government Relations for RWE Clean Energy. That's B as in boy, ROLIN. My address is 531 West 142nd Street in New York, 10031. I'm not here to speak about the Intervenor Support Grant Program, but I really did appreciate the presentation by Ms. Demiraj. I'm really excited to see what the program can accomplish and what the DPP can do here in Massachusetts, potentially as an example for other jurisdictions. So that was really fantastic. But I am here to talk about the draft guidance on site suitability. Since the adoption of the Biomap 2 GIS layer for regulatory purposes in the SMART program several years ago, land use regulation around solar in the Commonwealth has been among the most restrictive in the nation. This has stymied the growth of renewable energy generation in the intervening years. Now, we're appreciative of the legislature and the administration's efforts to streamline the complicated and lengthy siting and permitting processes across the Commonwealth to reduce costs, speed up deployment, and ensure effective stakeholder engagement. We believe, however, that the draft guidance on site suitability, as written, while well-intentioned, will have impacts that run counter to the governor's vision and to the intent of the 2024 Climate Act. Massachusetts must deploy solar and storage at an unprecedented scale and pace. And as currently drafted, the guidance introduces additional red tape, and most importantly, it goes above and beyond requirements that apply to other uses available to landowners, uses which have substantially more negative impact than creating meadow habitat over which solar panels will be placed. And that's really the main point of my comments tonight, the counterfactuals. Because too many stakeholders concerned with losing forest or farmland to solar and thus seeking to impose strict restrictions on solar development fail to finish the sentence. What's going to happen to the land if a distressed family farm can't turn to a solar lease for a portion of their land? It's not solar versus farms, it's solar versus subdivisions. The American Farmland Trust has published several reports in recent years to demonstrate that it's not solar that is resulting in the loss of the majority of farmland, it's low-density housing. You'll note that I'm using air quotes when I say losing farmland or forest to solar. That's because unlike subdivisions or strip malls or Amazon distribution centers, if you take forested or farmed land out of that use for a period of time to put solar on meadow habitat, when the solar farm is decommissioned, you can refarm or reforest that land. If you put McMansions on it, you're never farming it again. So I encourage the department, the board, and all stakeholders to think carefully about how they think about solar on the Commonwealth's natural and working lands. because solar is the only land use change which can provide economic benefit to our rural communities, to say nothing of greenhouse gas reduction, while also preserving our invaluable natural capital for future generation in the form of our soils. That should be the lens through which we consider regulations around land use for solar. Thank you.
Thank you. All right, next up on my list, I have Sonia Jindal online.
Yes, hello. My name is
Good evening.
Sonia. Hi. Good evening. Thank you for the opportunity to speak tonight. My name is Sonia Jindal, and I'm here on behalf of the Environmental Defense Fund. We appreciate the department's work to establish regulations to implement the Intervenor Support Grant Program and your commitment to equitable participation in energy decision-making. As Massachusetts navigates its clean energy transition, the stakes for communities could not be higher. This program isn't just about expanding access, it's about ensuring that those very communities are at the center of the decisions shaping our energy future. The 3 recommendations I'll highlight tonight share this goal, giving affected communities not just a seat at the table, but the tools and pathways they need to speak with power and contribute meaningfully to the record. First, expand eligibility beyond adjudicatory proceedings. Some of the most consequential decisions, from rulemakings to investigatory dockets like the future of gas, take place outside formal litigation. If we truly value public participation, this program must cover all proceedings that materially affect affordability, emissions, or community well-being. Second, allow individuals to serve as grantees. In many cases, the most meaningful contributions come from people outside formal organizations. Other states such as California and Wisconsin have implemented this process. Excluding individuals limits the diversity of experience and insights that this program is designed to support. Third, provide proactive technical assistance. Many under-resourced organizations know what needs to be said, but may not know how to navigate an unfamiliar regulatory process. Offering workshops, office hours, or plain language guidance can turn barriers into pathways for meaningful engagement. Each of these recommendations reflects the same principle. This program can fundamentally shift who gets to shape Massachusetts' energy future, but only if it's designed with intention and equity at its core. These points, along with others, will be further memorialized in our written comments that the Environmental Defense Fund will file later this week. Thank you for your time.
Thank you. Next we have signed up is Hassan Farouki. Did I say that correctly?
Hey. Well, hi. Thank you all so much for the opportunity to testify. My name is Hassan Farouki. I can spell it out as well. HESSANN and I live at 217 Albany Street in Boston. I'm also here as executive director of the Boston Climate Action Network, or BCAN, which is a community-based organization.
I'm so sorry. Could
I'm
you get a
talking
little
too
bit
quickly.
closer to the mic?
All right.
Actually,
Sure.
it's just, yeah, thank you.
All right. This is good?
Yes.
Okay, great. Thank you. So yes, I am executive director of Boston Climate Action Network, or BCAN, and we're a community-based organization here in the city. I'll focus my remarks first on the Intervenor Support Fund, which is a great thing. It makes a huge difference for community-based organizations like ours to be able to participate in dockets like these. I think there are I think the regulations overall are good and they're helpful to community groups. I want to flag a few things in particular. Having a 10-day turnaround for the applications after they're submitted, great. I wish that was what other people did. This is really, really helpful. I also think that having an option for groups to be paid upfront is a huge thing, and I hope that that stays in the regulations. Reimbursements can be completely unworkable for organizations that don't have a lot of money already. And having an opportunity for fiscally sponsored groups to participate as well is very helpful, because a lot of the groups that you really want to hear from are not formal 501c3 nonprofits. They're sometimes fiscally sponsored, in many cases may not have any kind of legal structure at all, which I know is another issue that we'll want to work out. And we will submit written comments with different organizations that we can envision who will be, potential fiscally sponsored groups that could support those kinds of residents. In terms of the, a few concerns, always with these kinds of things when we're asking groups to demonstrate their hardship or asking for any kind of information at all, the amount of paperwork that we're asking for can often be unworkable for the groups that are really needing to be in spaces like this. So to the greatest extent possible, minimizing the level of information that we're asking for, both in applications and in reports, is really helpful because unlike a lot of the larger nonprofits that you may hear from more often, small community groups like ours don't even have one person to do all of the report writing and applications, let alone a team. So those things are helpful. And then finally, I think in terms of the restrictions around the use of funding for advertising and marketing, I think this makes a lot of sense. There are definitely circumstances that we wouldn't want to see that funding be used. And there are places where groups may want to help get the word out about proceedings to their membership and to their residents so that their residents can better participate in these proceedings and understand what's going on. That could constitute advertising to some people. And, that's a use case in which we think it'd be very helpful for groups to be able to use funding for staff time to make that kind of communication to their residents. And so I hope that that kind of flexibility can be allowed for in the final regulations. And then finally, I'll just voice my support for written comments that we've already submitted alongside the Green Justice Coalition, which we're part of, with respect to other parts of these regulations, which are around example commitments that we can make for community benefits agreements and other types of things and projects, particularly things like project labor agreements and funding for making sure that there's childcare and transportation to work sites. These can be a make or break difference for a lot of the residents in our neighborhoods being able to get jobs on these construction sites. And we want them to be able to do that. So those kinds of things can be really helpful for developers to understand. So I just want to thank in closing all of you and the DPU and the EFSB and everyone for all the work on this, and look forward to collaborating more. Thanks.
Thank you very much. I do see a raised hand online for Adam Reynolds. If he is or if that person is interested to comment this evening, we can elevate him to a panelist.
All right, Adam, you should be able to, yep, looks like you got it.
Thank you. Good evening. My name is Adam Reynolds, Reynolds, and I'm a legal fellow with the Conservation Law Foundation, CLF, at 62 Summer Street, Boston, Mass. CLF has submitted written comments on October 17th for the DPU's 2575 rulemaking regarding implementation of the 2024 Climate Act. And CLF plans to submit additional comments and recommendations ahead of the November 17th deadline. CLF appreciates the opportunity to comment tonight on the proposed regulations issued by the DPU and to highlight some key priorities related to the Intervenor Support Program. Our comments focus on how this program can be made more accessible to ensure that the program does not impose barriers that it is designed to remove. The Intervenor Support Program aims to increase access and meaningful participation in DPU and EFSB complex administrative proceedings, but several parts of the regulation need improvement. First, CLF proposes that the DPU make the regulations clearer by defining terms like significant financial hardship and undue hardship, and clarify terms like group of individuals and unique perspective. Second, the DPU must also clarify the threshold that will be used to decide how a group can qualify for the program. Regarding substantial contribution to the proceeding, the department should presumptively recognize the value of community knowledge and define at least a baseline standard for what evidence will meet this definition. Third, the level of documentation required may be overly burdensome for small grassroots organizations. It will also be important for groups to have the option to amend and supplement materials provided to the department throughout the application process. This flexibility should also be built into the project timeline. Fourth, regarding denials, the department should set forth a clear and objective standard for denial decisions and a requirement that denials clearly lay out the reasons that the application was not approved. Additionally, the department should remove the requirement that the names of all members of a group be disclosed as this raises significant privacy concerns. Currently, the regulation as drafted is ambiguous in some areas, and this risks inconsistent and arbitrary decisions. Ambiguity may unfairly limit meaningful public participation, especially for community-based and environmental justice members. Before issuing the final regulation, the DPU should aim to clarify these points to ensure that the program meets its intended goal of increasing meaningful engagement and participation in proceedings. More detail is provided in CLF's written and submitted comments. And thank you again for considering these comments and working to implement the 2024 Climate Act in a way that will create a cleaner energy future while accounting for the impacts on environmental justice communities.
Thank you, Mr. Reynolds. I do note that you mentioned CLF would be filing additional written comments. So to the extent they are able to provide any example language for us to consider, we would certainly welcome that in any additional comments.
Okay, thank you very much.
Thank you. And I do not have anyone else signed up to give comments this evening, so opening it up to the room if anyone would like to provide comments, and also opening up to any additional participants online. Okay, we are going to end. Oh, I do see a hand raised online. So the initials are RL online.
Can you hear me?
Yes.
Yes, we can.
Okay. My name is Rachel Leffler, spelled the last name Loeffler. And I had a question about the interaction between the grant program and applicants. Will there be someone at the department to help guide organizations and individuals who are unfamiliar with the application process and the award program to guide them through all the paperwork and all the steps to make sure that they have the best chance of success?
Rachel, thanks for your question. Yes, the Division of Public Participation and staff at the division will be available to guide applicants through the process. We will also be creating a number of resources that will be available on our website, both things that, there'll be template forms. There'll also be videos that are created that take the applicants through the process, and staff will be available to answer questions as well.
Thank you.
Okay, thank you very much. It would be last call. I see an in-person hand raise. My last calls are working to get more participation.
Hi, good evening. My name is Jessica Friedman. I work at the Attorney General's Office in the Energy and Ratepayer Advocacy Division ERA, E-R-A. Thank you. Our office will be filing comments by the deadline on Friday, but I believe Hearing Officer Desmet did say that staff and commissioners may be able to respond to questions. So I do have two. If you can't respond, we understand. But these are a couple of things that the office is thinking through as we finalize our comments, our written comments. The first is, as the EDF representative noted, the current definition of proceedings specifies that proceedings are adjudicatory proceedings. And as the department knows, there are several other types of proceedings that participants regularly contribute to. So I can pause. I'm not sure if the commission or staff is able to discuss their thinking on that choice.
things you would like us to consider on that point, please file your comments, and we're receptive to any feedback. And as the hearing officer said, any proposed language. That's why we're here to hear your comments on that.
Okay, understood. Thank you. I figured I would ask since I'm here. And then the other question I had is that my understanding of the authorizing legislation is that the substantial contribution requirement was a reporting requirement rather than a requirement to be discussed in an application. And it looks like the draft regulations in 220 CMR 3403 list that a prospective grantee must include how they're going to substantially contribute in their application. So same question, just wondering if staff or the commission is able to comment on their thinking around that.
I can attempt to answer your question. Yes, the statute does specify that it is a reporting requirement, but as it is something that the applicant or the grantee would need to report on, we don't want that to come as a surprise when they're creating a report and to have them start thinking about it when they are applying. And that's the reason we included it as a part of the grant application itself. But we're open to suggestions and feedback on that.
Thank you so much. And we do intend to file redline proposed changes to the regulations and offering general support. And thank you for the department for all your work on this.
Thank you very much for those added comments. And again, maybe my last sales pitch. Anyone online that would like to raise their hand, make any comments? Or anyone else in the room this evening that would like to make comments? Okay, seeing no one additional, I would like to extend my gratitude to all who attended tonight's hearing. Thank you for your participation, your time, and your comments. Thank you to the commission and the rest of the DPU staff who have been working on this important program to support interveners in dockets before the department and the Energy Facilities Siting Board. I'd also like to extend my gratitude to the Energy Facilities Siting Board. I know they have had a Herculean task pulling all of this together as well, so I congratulate them on that endeavor, and there's still more work to be done. I would like to remind everyone that the slides will be posted online for you to view, and the department is accepting written comments until this Friday, November 7th. Lastly, the next public hearing is this Wednesday, November 5th at 6 p.m. at the North Shore Community College in Lynn, and the hearing has virtual participation option as well. Thank you again. This meeting is closed and we are off the record.